Hi guys, welcome to class 4. This is our main part, basically chapter 3, I think, of Hemes, talking about finding and reading case law. Okay, so what are cases? We've talked about this before, but they are opinions, decisions written by a judge, and in the opinion, the judge gives the reasons for the ruling, or the judge writes them out, and these reasoning and these rulings have the force of law. Okay. They don't just say, here's the law, 1, 2, 3. They have a different format, right? They talk about the legal and the underlying basis for the case, the legal and factual issues facing the court. Then they look at the laws that apply and they interpret them and then analyze them. They apply that law to the particular set of facts that is before the court. And appellate court decisions, it's not just one judge. Don't think Judge Judy or Judge Wapner. It's a panel of judges. And out of that panel, one judge writes the official opinion. And the official opinion is what is law, which can be binding on future lawmakers or judges. So if a judge is on this appellate court panel and disagrees, the judge will vote against it. It's just a majority of decides what the opinion is. But if a judge disagrees with the majority opinion, they may write about it. They write what's called a dissenting opinion. So if you see a dissenting opinion in a case, it doesn't have the force of law, but you might want to read it to see what the different analysis is. If the judge agrees with the majority opinion, but has a different reason for it, they will vote with the majority, but they will write their own opinion, and they call that a concurrence or a concurring opinion. So it's the same result, but for different reasons. Okay, stare decisis. So we have a case law, it's a written decision, it's primary authority, and case law can be what we call precedent, which is binding on future cases. An example by an earlier court. So it's said once, and then it's decided once, and then they say it stands decided. Now, case law is precedent only, not for every future opinion. So stare decisis or precedent to apply, the opinion has to be a published case opinion. So when an appellate court case is written, an opinion is written, the Supreme Court, the head of that court decides which ones will be published and unpublished. So published ones have the option of being precedent. Okay. It has to be in an appellate court. So trial court opinions are not stare decisis. Okay. Has to be in the same jurisdiction. So if it's an Illinois appellate court, yeah, that's the same jurisdiction. And a higher court. So if I'm in the trial court of Illinois, then an Illinois appellate court or an Illinois Supreme Court case will be precedent on me, or stare decisis will apply. If I am in an appellate court and there's another appellate court decision that is authority and it is persuasive, but it is not binding precedent, it's not mandatory for me to follow those. So it's a little tricky for people. You think if it's just in the same jurisdiction, the court has to follow it. No, the strict rule is same jurisdiction, higher court, published case decision. Here we go. When it applies, we call that mandatory authority or precedent. And trial courts, they always have to follow the decisions of the higher court in the same jurisdiction. So in a great courtroom movie called Anatomy of a Murder, there's a great scene where Jimmy Stewart and his law associate are researching in the law and authority, and they find a case which is precedent, and they then present it to the judge. So there's just, it's quick, it's fun, but in this same section of the learning module under this video, these two, they're like 2 minutes each. So definitely watch that as an example of when a precedent applies. Okay, so an appeal process. So that is also in Hamey's, page 60. How does an appeal go? Okay, so we have a case. Well, let me go from here first, and then I'll go. So, there's a party, there's a case, and there's a judge's ruling, and one of the parties is dissatisfied with the legal ruling of the court. Usually, this is in the trial court, and a party will have the right to appeal. Now, the time where a party does not have the right to appeal is in a double jeopardy situation. So, in a criminal case, if a defendant is found to be not guilty, the prosecutor, then the state cannot then appeal that, so they have no right to appeal. So anyway, but any other situation, a party may have the right to appeal a legal ruling of a court, and they file a petition for writ of mandate. In Illinois, we call it a notice of appeal. Okay, so then it goes to the appellate court. There's briefing, all sorts of stuff going on. Then there's an oral argument, and then the judges make a decision. And depending upon what that decision is, there is what we call a disposition, right? So the disposition is how this appellate court decision affects the lower court case. Okay, vacate it means they just like pretend it was never there. That decision never applied, and then here's what the ruling is. Affirmed means they agree with the decision of the lower court and it stands. Reverse means they disagree and it no longer stands. And sometimes they reverse and remand. Remand just means they kick it back to the trial court, and then they have to retry the case based on this new legal ruling. Now, say the appellate court has made their decision and you are a party which is unhappy with the appellate court decision and thinks they made the wrong decision, you can appeal again. Now, you do have a right of one appeal. The second appeal to the higher appellate court is not a matter of right. It's really up to the court that you are appealing to see if they want to take the case. They want to hear it. So it's usually if it's something interesting or new, or the court finds that they haven't decided this before, or they need to reiterate their opinion or the law on this particular issue, and then they will accept that appeal. So for the Supreme Court, they call that a petition for the writ of certiorari. You might see it abbreviated CERT, CERT, period, is an abbreviation for that. So your basis for appeal, you can only appeal if there is a claim of legal error. Okay, so it can't be, well, the jury made the wrong decision. So that's not a basis for appeal because that is a factual error. You can never appeal a finding of fact. So it has to be a legal error, and it has to have been raised in the lower court. So I'm sure you guys have all seen trial TV shows and trial movies where I object, Your Honor, right? Even if they know that the judge is going to rule against them, they have to raise that objection to preserve that legal issue for appeal. They have to give the court an opportunity to make that legal decision in their favor. And if the judge decides otherwise, then they have a legal basis for appeal. So they might say, oh, I think this testimony is inappropriate, right? So an evidentiary ruling. They said, no, sustained, we're going to allow it. Or this piece of evidence either should be introduced to the jury or not introduced. Or any motion, moving to dismiss or moving for jury instruction or something like that. So you have to have raised that legal issue in the lower court. But you cannot, any jury finding a fact cannot be appealed, or when a defendant is acquitted, then they're done. There's we call that double jeopardy protection. Okay, let me go back to this chart on page 60. So if a factual dispute is resolved at court, then there's no case law, right? Because we cannot, it's just done, right? Or if you don't like that, then you're kind of out of luck because you cannot appeal a factual issue, a factual determination. So if there is someone appeals an intermediate appellate court, then the appellate court will review the case and render an opinion, and then this opinion becomes case law only if it's published, right? Published is what is the potential for precedent or mandatory authority. Then that is your case that you're reading. Now, the losing party there may seek review in the highest state court. So they're filing a petition for writ of certiorari, and then the high court can say, yeah, we're going to listen to it, or no, we're not going to listen to it. And if they grant the hearing and it reviews the action and it renders an opinion, that would be case law here. If there is a constitutional issue at the state level, the losing party can request a hearing before the U.S. Supreme Court. Again, they'll file a petition for writ of certiorari. And if the court then grants a hearing, they will write an opinion, and that's that. So a motion is a request for some sort of order from the court. Can be you're just asking the court for something. I'm making a motion for an extension of time. That's motion. I'm making a motion to dismiss. That's motion. I'm making a motion for summary judgment. That's a motion. Those are all requests for the court to do something, and the court makes a decision one way or another on that. Okay, so we've talked about how this case law is made, where it comes from. Now, where do I find them? If I'm looking for them, right? This is finding and analyzing case law. I think that's the name of this chapter. So we have the option of case law reporters. We've seen them before. I've showed you pictures of them, right? You have books, Illinois Decisions, Supreme Court Reporter, right? It's the volume of book that contains case decisions. So you have them in books, or we have Loose Leaf Services, which is a binder which has case law decisions in them. Okay, then we have our paid online databases like Lexis and Westlaw. Super great way to find court decisions. And then we have our free internet sources like Google Scholar. And be sure in this learning module to look at the little section on how to use Google Scholar. You can go to the court where that decision was made and find the text of the decision. Sometimes it's hard to maneuver around those unless you have the particular docket number or name or date that it was decided. We have the Cornell website, which is the Legal Information Institute, things like that, free internet sites. But those are places where we find them. These case reporters, when we are citing to them, the official reporter, the book that the state or the governmental authority relies on, must be always listed in your citation, and it must be listed first. So in the United States Supreme Court, it's the U.S. reporter. And in Illinois, now it's that virtual public domain citation that I talked about in the Blue Book citation section. Okay, and it must be included in any citation. All right, so our federal case law reporters, and this I have in that cheat sheet that I included in the Blue Book section, but our official reporter is the U.S. Reports, and those are our unofficial reporters. For circuit courts, there's only one reporter, the federal reporter. In these, because there are more than one court in these federal reporters, you need to include the circuit court in the parentheses before the date. The trial court, these decisions, remember, trial court decisions are not precedent. They can be used for persuasive means, but never are mandatory on a court. There's a bunch of them. Federal supplement, federal rules decisions, the bankruptcy reporter, tax court reporter, a bunch. And if you are citing to those, always include the court. State reporters. Oh, what's this? It's a link. I hope the link still exists. University of Chicago. Not helpful. All right. Illinois report, that will probably have other ones, but Illinois reporter reports is official. Those are official for as long as they exist into June of 2011. Our regional reporter unofficial, Illinois decisions unofficial. And then post June 2011, we have this public domain citation, which is our official reporter. Remember, you always need to cite to the official reporter for proper Blue Book. Okay, why do we read court decisions? Because appellate opinions have precedential effect. Judges need to instruct those who are reading decisions as the basis of the reasoning because we need to know when the law will apply in the future. Okay, they use things like facts, constitution, statutes, prior decisions to make their ruling. And they give detailed analysis of the reasons to help future courts and future people on their behaviors. Okay, so things to do when we are reading through the opinion, and this is what we'll work more on when we're doing our briefing section. Figure out what the facts are. Okay, there are two kinds of facts. There's facts, which is the underlying situation, and maybe the procedural facts. Why did we actually get to this point all right, so the facts are the lawsuit was filed, why the lawsuit was filed, and then the judicial history. How did we get to this point? Was it a motion that was denied? Was there an evidentiary ruling? Was there some sort of procedural matter that is being appealed? So that's your judicial history. The issues are legal issues that the court is deciding. And, we talked a little bit about that last week, how to formulate a legal issue. It has to be a question that includes both the facts and the legal conclusion. The rules. Okay, so what laws is the court applying? Are they cases? Is it a statute? Is it a constitutional section? What laws? Is it a common law doctrine? What laws is the court what are they interpreting there? Okay, our analysis. Analysis is the part where the facts and the laws are combined. Okay, so if the law has three elements, boom, 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 you go through your facts. Are all of those three elements satisfied? If they are, then yes, the law applies. What's different between the facts? What's missing? What can be interpreted to apply? So that's your analysis. Then the conclusion is the answer to your issue questions. It's not the disposition. Remember, we talked about the disposition just has to do with, what happened in the prior case. So that is not your conclusion. The conclusion is the answer to the issue question. Issue is a question. Conclusion is an answer. Disposition is helpful, but it's not really, the conclusion is not the place for it. Okay, so we call this the IRAC format, and you'll use the IRAC format for a lot of legal writing. Okay, issues, rules, analysis, conclusion, but you do want to add the facts to that, because if you just do that, you're missing what this case is about. It won't be helpful to you. So, Hamies has some ideas on, I don't know why I can't just get here. 38, am I here? Oh, it's chapter 3. I'm here, okay. Federal case law, we did this. State case law, we did this. Okay, an approach to reading a case. That's what I want. Okay, that's my facts, judicial history, issues, rules, analysis, conclusion. So First time you're reading a case, you might feel like you're at sea. You don't know what you're doing. And just give you an idea of different approaches. So if you go to this Kabbalist case on page 68 and you just wrote down the first sentence of each case, of each paragraph, it's kind of a way of saying what happened. Okay, it's a way of, you get a good picture of the facts, the issues, and the outcome. And then maybe it helps you figure out what it really means. Okay, another thing you can do, I had some friends in law school who loved color. And this is, it's just a matter of personal preference, but they highlight pink for facts, blue for issues, green for rules, yellow for analysis as a way to, you highlight it first. And then when you're done, you can pull out things for your case brief. So, that's all about, how your matter of personal preference. So that's not what I really want. Okay. So they have this Kabbalos, which kind of, here they're saying this is our facts, this is our judicial history. So it's just kind of arrowing. Here's our issue. One thing you said, the question which we granted certiorari is, so here's your issue. And then your analysis starts. Okay, more analysis, more analysis, more analysis. And your holding, which is your conclusion. It's really your answer. I don't like that. So this one is remanded. That's really your disposition. I disagree with that. So I have posted in the learning module a case for us to kind of look through together. Called Trump versus Hawaii. I think I got this on maybe Google Scholar. It was pretty early when this case came out that I downloaded it. But I have like little notes here. Okay, so here's my case. Trump versus Hawaii. So this is my case name, Trump v. Hawaii. At this point, there's no official reporter site, so I would just use, so you can use the Lawyer's Edition second or the Supreme Court Reporter section until then. There's probably an official reporter site right now. So it would be Trump versus Hawaii, 138 SCT 2392, and then 2018 is your date. Okay, so here, this synopsis is an editorial enhancement. I wonder where I got this from. Okay, you can't cite any of this. Is this Supreme Court? I must have gotten this from Lexis. This is, stuff that an editor read and kind of helped you summarize. So it's not the text of the opinion, it's a synopsis, and you don't cite to this at all. It just helps you explain about the case a little bit. Okay, close that. All right, here, this is my disposition. It was reversed and remanded. Okay, remember we talked about concurrences and dissents. So we have 2 dissents. 1, 2, 3, 4. Wow. So only 3 people agreed on the outcome and the reasons for the outcome. So everybody else kind of disagreed a little bit. Okay, so that's your who took it's West. I got this from West, so I don't know what I'm talking about. Okay, so we have head notes. Head notes are the kind of a way to index cases into legal issues that future researchers can find them when they're interested in these issues. You'll need a digester when you use Westlaw. You can use head notes as well, but don't quote head notes or cite head notes as law. Okay, so look at this. So this is a general topic, aliens, immigration, and citizenship regarding an injunction. And then they go down to, look, itty bitty topics, and each of them are assigned a number. And then they give you a little blurb about what that means. So we have a bunch of head notes. Head notes, head notes, head notes. These Supreme Court decisions are buku pages. Okay, keep going, keep going, keep going. A lot of head notes. Okay. So then we get here. This is the syllabus. That's the beginning of what is written by the judge. They give you a summary of what is to come in the opinion. It's a good place to get an overview of the case. But again, don't quote it as law. It's just kind of a little outline. So that's your syllabus. Okay, then we get to the point where we have our facts. Okay. 3 individuals with foreign relatives were affected by a suspension, and they argued that the proclamation violates the Immigration and Nationality Act. And so that's kind of your facts. And then here's like judicial history. District court granted a nationwide preliminary injunction. So there's your, judicial history. Okay. And this is the holding. So this is the end, right? The answer to your issue questions right here. Yeah, those are my Supreme Court holdings. That's kind of the end. So they're giving you everything out in the beginning. And let's see, where do we have held? I want to this is too big. Okay. Okay, so these are my 2 holdings. And then here's like my laws. I have 180F, that's my rules, and 182E and 182F that they're looking for. And this is my analysis in here, and here is my disposition. Okay, and then here are my who voted which way, and then we have our dissent. Oh, holy cow. We're not even at the opinion yet. That makes more sense. Okay, here's my opinion. This is where you can start quoting things. There we go. Here's my rules. Rules. I knew that didn't make sense. Okay, rules. And then here is my facts. Boom. A lot of information on facts. Here's my procedural history. And then here we go. Here we start talking about issue 1. And then issue 2. So the issue 1 is dealing with one of these sections, 182.1 or whatever. Here's the text of 182F for issue 2. And this is my analysis in here. So yeah, issue 1, this is subpart 152. What's this one? Issue 2, the constitutional challenge and standing. Scroll. Okay, this is where they are reversing the district court's injunction. And here's my concurrence. Here's my other concurrence. And then you get your dissents after that. I know Sotomayor wrote a really long dissent. So again, the dissents you do not cite to as law. So that's just kind of an outline of one case. And we will go through more cases as this semester continues. Okay, so in summary, remember case law is our primary authority. It's a rule of law. It's mandatory authority or precedent. The theory of stare decisis applies if it is the same jurisdiction, higher, it's not the same level, higher court, same or similar issues with same or similar facts. Case law that is not mandatory authority, we call that persuasive authority. Okay, remember always to cite in Blue Book form, like we went over in last week's module. Opinions can be found in case reporters. Remember to always cite to the official one. And our opinions are divided into facts, procedures, issues, rules, analysis, and conclusion. Okay, so that's our first part of our lecture for today. Reach out to me if you have any questions.